Good evening, everybody. My name is Patrick Fisher. I'm the Executive Director of Erie Arts and Culture, and I want to thank you all for joining us this evening for a installment of our Pro Network. Erie Arts and Culture believes that artists are assets in our community and can become community leaders when they are provided with access to professional development resources and opportunities. And as the arts agency serving Northwestern Pennsylvania, that's certainly part of our responsibility within the region that we serve. Through the Pro Network series, which is funded in part by the National Endowment for the Arts through their Artworks grant, we come together for these webinars where individuals across the nation share their knowledge with us, specifically geared towards artists and tips and tricks and techniques and information that are all designed to help artists scale their careers as well as implement sustainable business practices within their careers. This evening, we are joined from Jacksonville, Florida by Obi Umunna. Obi is a business attorney and political consultant based in Northeastern Florida. Obi is the founder and managing partner of Umunna Legal Group, a full-service law and mediation firm dedicated to being a bridge for businesses and individuals. Obi has been featured as an influential Politico, lawyer, and advocate for several publications with client features on CNN, BET, Fox, CBS, and more. For almost a decade, Obi has been committed to not only changing the way legal representation is being offered to clients, but also being an advocate for strengthening the Black vote. Obi, thank you for joining us this evening.
Thank you for having me, Patrick. I know Patrick from his time here in Jacksonville, so it's an honor for him to request me back to come out to Erie, and so I'm very grateful for that. I think I'm going to share my screen and kind of start my presentation here, and then what we'll do is we'll save some time for some questions at the end.
And Jade, you need to make Obi a co-host so that he is able to share his screen. If you could please do that now.
Okay. You're now the co-host.
Wait 1 second here. All right. So like I said, my name is Obi Umunna. I am an attorney. I've been an attorney for 15 years. And for the last 10 years, I've had my own firm called Umunna Legal Group, where we help small businesses and particularly artists kind of understand how law can help their business. And that's why I'm excited to be here. I've always wanted to be an artist, but I've never been able to draw. I can barely draw my own hand, but I represent a lot of artists and small businesses in Jacksonville. But I do have kind of one issue with artists, and that is this. Artists don't consider themselves as businesses. And actually the opposite is true. You know, you need to think of yourself as a small business. If you don't, you will get abused and neglected in your business, and you won't be able to do the thing you love and be able to make money doing it. And so it's super important for you to kind of have a mantra that I am a small business and I deserve to get paid. I want to kind of start, just because this is a general presentation, I want to start with some legal terms that you hear from time to time. And then I'll go into kind of more specifically contracts and things that you want in your contract and stuff like that, so you know kind of where we're at and what you should be doing with your contracts. So first, let me go over a couple of terms that you probably heard from time to time. And I think it's important to kind of get these terms in order for you as an artist in a small business. So there's three kind of main terms that you hear from time to time. There's copyrights, trademarks, and patents, right? The difference between a trademark, copyright, and patent, they all serve different functions. So for example, a trademark is used to protect the business. A copyright is used to protect artwork, and patents are used to protect inventions. So the purpose of copyright law is to protect the creator of work against infringement or to guarantee commercial exploitation to stimulate new ideas. But what everybody gets confused about is what is the creator? In copyright, the author of the work is a creator, not the printer who produces the work. Under copyright law, the creator is the originator of the work, and the person who basically uses mental thought to create the work. Funny thing about copyrights, and copyrights is a lot of what visual artists and other type of artists will use, copyrights happen at the time that you create the work. Really, it happens at the time that it's shown to third parties. So for example, if you post something on Instagram, you actually automatically have a copyright. But the issue is you can't sue someone for your copyright unless it's registered with the United States. So copyright law protection comes right away once you post it. Trademarks, again, are for businesses. To trademark a business, so no one can use that business. But patents are very simple. As you can see, shake weights, patents are for inventions. And so for you guys, what I like to do, a quick thing to think about when you're thinking about trademark, copyrights, and patents, trademark would be for the art gallery, copyright would be for the painting, and a patent would be for the paintbrush. That's how you can think about the differences between the three things. So now that we've got that, let's go into contracts. And I'm telling you, I have one major thing that I think artists need to do, and here it is. Don't start a job without a contract or a deposit. Don't start a job without a contract or a deposit. Why do you need a contract? First of all, having a contract prevents you from issues of non-payment, which to me as a lawyer, that's the most important thing. You're doing this because you want to survive and live. Having a contract helps with that. It helps the client first know what they're going to receive. Contracts will outline contingencies for worst case scenarios. And also having a contract presents you, but it also protects the client. A contract is not going to be able to present every bad thing from happening, but it can help prevent, it can make it easier for you. The other thing is, even if you know them, they still may cheat you. And so that's why contracts are important. One of the things I like to tell artists, why it's important for you to have your own contract is because you want to have your issues brought to the forefront. If you're always signing somebody else's contract, your issues may not even be in that contract, and you need to make sure that your issues are taken care of. And so particularly ask all artists to have their own contract. That way their issues are taken care of. So why do you need a good contract? And this is a picture from a movie about New Edition. I don't know if you know who New Edition is, but New Edition is a boy band that was back in the day that went out on tour, and they sold out arenas, and they basically got $1.87 per person. And basically, I use this picture to show you, just because you sign a contract doesn't mean it's a good contract. And so I want to tell you 8 things that you need in your contract, but these are also 8 things you should be looking at in any contract that you sign. So here are the 8 things you need in your contract. First, pricing and rates, right? To me, I'm a lawyer, that's the most important thing. How do you get paid, right? So simply, are you going to get paid by hourly, flat fee? Are you going to get paid half when it's done, half at the end? Are you going to get paid on certain kind of certain times? Also, invoices. How soon after completion will you get paid? The third one, which is super important, especially when you're working with the business, you have a single point of contact. Sometimes you may know you work on some of these projects, and there's several people giving you what to do and what not to do. So it's important to make sure you have one person in the contract that if that person says something, you know that's gold. Next thing, how do you end early? It happens. Sometimes situations do not work out and you need to end the contract early. Sometimes it just doesn't work. So how do you do that? How many days notice do you need to give them? How much time can go past? What do you get paid for? It's super important when you're doing your own contracts to make sure you get paid for all the hard costs that you at least put in and maybe more. If you're signing someone else's contract, you may not get paid for anything if you quit. And so it's super important to look about how the termination part of the contract works. The next part, which is a big part for artists, all different types of artists, revisions, rewrites, and change orders. During the course of a project, you have some clients that will just say, hey, do whatever you want. Then you'll have other clients that will constantly give you change orders or change their mind about what they want. And it's important for you to understand how that process works, right? If they change it, is there a price increase? Is there a price decrease? How do they tell you in a change? Is it in writing? Can they send it by text message or an email? You know, you want to be sure that you kind of get an idea of what happens when you change your mind or the client changes their mind. IP, intellectual property. This is one that artists don't think about enough. Who owns the project when it's done, right? I'll use a photographer, for example, right? So a lot of times the photographer will deliver certain final pictures that are edited. Who owns the ones that we're not editing? Who owns that? You should have that discussion. Who owns the B-roll for a videographer? Who owns that, right? Can you use that? Can the person use your work in other places, right? Can they go sell your work to other people? Those are things that you need to talk about in your contract. And for every kind of discipline, there are different IP issues. And we can, if you have those kind of questions in the question part, we can talk about that. Kind of the final thing is, what are your deliverables? What are you actually going to give them? Is it a mural? Is it a painting? Is it a book? What is it going to be? Is it a play? What is that final thing that they're going to get at the end of the day that says we're done, right? What is that thing? And then finally, deadline. When should you expect to deliver the project? What happens if you don't deliver the project in time, right? What is the deadlines? What are the times that you need to make? These 8 things are the things that you need to have in every contract. But also, if you are signing someone else's contract, you need to be looking for these 8 things and make sure these questions are answered. Questions. We'll open it up here. I'll stop sharing my screen here and we'll go back.
Obi, I'll start us off with the first question. We are currently consulting on a public art project, and the artist that we are working with lives in Los Angeles, and obviously the work will be transported here to Erie. And one of the points that she raised regarding the contract that we originally provided and raised rightfully to have it added is, when is the transfer of responsibility and liability? Is it when it's shipped out? Is it when it's received? Is it when it's in transit? So I think that that's another issue that especially artists that are delivering public work or sculptural work or something that has to actually be shipped, thinking about that transfer of liability and responsibility.
Yes, and that's another good question to answer. Whose contract are you signing, right? If I'm you guys, I don't want the responsibility till it hits Erie, right? If she's doing it, she's going, once she puts it on the wherever the plane or wherever she's sending it, she wants to be done with responsibility. And those are the kind of things that you want to haggle out in the very beginning, because who's going to be responsible for it, or you agree on like the shipment, the way it's going to be shipped, right? And then there's insurance kind of paid for it ahead of time. So there's different ways to kind of handle the issue, but it does matter who's writing the contract, right? Because if you're not looking out for your own interests, once it leaves her door, you guys are now responsible.
So within the group this evening, do we have anybody that has had any issues or conflicts arise either because of or a lack of contract, or do you have any questions about developing a contract that serves your needs based off of a specific artistic discipline?
Well, I'll just say that I'm a ceramic artist. I make wall art and bigger pieces like installation. And honestly, I have not, it's always the galleries that kind of do the contracts I'm not a big name yet, but I actually have a commission that is hopefully going to come through, somebody who's interested. So that would require a contract, and I have no idea what I should. So that's why it was perfect timing that this came up, because it gives me. And where can one find samples of this? Is there any place one could find samples?
So I think I'll be honest. I'm an attorney. I do contracts, but I would go online and look for contracts, right? Like I think I would. That's where I would start. If you don't have the money to go out and hire a local attorney, usually you want an attorney from your state, just because of the way our licenses work. But you can use attorneys from everywhere for this kind of stuff. But you want to go and start looking at other contracts. And I would actually take the contract from the gallery as a good place to start, right? And then you look through and and I can send Patrick that graphic of the 8 things, so you can disseminate it to you guys as well. But you want to start looking for those things in the contract. Who are, what's going on, that's going on. But if you're writing your own contract, you want to start kind of figuring out what are those issues, right? Every type of artist has every discipline has different needs. A photographer does not have the same needs as a ceramic artist. They're different needs. And so you want to make sure that you are kind of doing what you want to do, but particularly with IP, it's so different, right? Are you going to get your piece back, right? Are they allowed to sell your piece, right? Those are not the same issues maybe with a videographer will have, right? What if they damage your piece? What happens then, right? Those are questions that I would be asking every gallery that wants to hold my art. So.
And Obi, that raises a point that I'd like to ask. So in Danielle's situation, where if she doesn't have her own contract, maybe the starting point is the gallery's contract. Hopefully they have one that they provide her. Obviously, as you look through it, you want to make sure that your needs are also being taken care of and advocated for in that contract, and that it's something that serves both parties. But if you have revisions that you want to make to a contract, do you recommend doing that as a red line within their document? Should it just be something that is verbally communicated to them? Can it be sent over as an email? If you are provided a contract as a starting point, what is the best way? One, should you view that as an end all be all, or is that actually a point for negotiation? And then if it is a point for negotiation, how do you recommend requesting those revisions?
That's a great question. First of all, everything is negotiable, right? You should never view the contract they give you as an end all be all. And if it is, that is a red flag, right? I mean, I just think, I'll just be quite honest, I've rarely had people make revisions to, I've made revisions to every kind of contract, huge multi-million-dollar companies, small companies, they've all taken revisions. Well, another thing they also take is clarification, right? They say something in the contract, what does it mean? So how do you go about doing that, right? There's different, I mean, it depends on who you're negotiating with, right? Some people are small people that you know, and maybe you don't want to say, hey, my attorney looked at this and he has these changes. Maybe you want to call them up first and say, hey, these are some of the things I was thinking about with the contract. What do you think about that? A lot of times the gallery hasn't read their own contract. They hired an attorney, they wrote it, and they just forwarded it to you. And so you say, hey, I read this, there's some issues. Sometimes you do want to have your attorney send over some red lines in the document and go from there. That part is hard to say. It kind of takes a little bit of time to know who you're dealing with, right? And what the relationship will be. I think most professional companies have no problem taking revisions to their contract as long as they're, normal and suitable. But I would say the minute someone says, we're not taking any revisions, that's probably not somebody that you want to work with.
I'll I'll answer or ask another question is, the contract is really intended to be a proactive measure to prevent anybody from being exploited or neglected, etc. What do you do if you have a contract in place and the entity you're working with or the individual you're working with is out of compliance with that contract? What are your rights and what is the process that you go about it? And how do you perhaps advocate for your rights based off of what's in your contract, especially if you are perhaps operating on a smaller budget and the idea of legal fees and other things might be a little bit concerning?
So that actually is another good question, Patrick. A couple of things I will tell you. And I didn't put this in the 8 things because it's not always necessary. But one of the things you can do to kind of help yourself, especially if you're on a small budget, is have what we call as an attorney fee clause in your contract. That allows, if there's a dispute, the winner of the dispute would pay the attorney fees. So for an artist that doesn't have any money, that will get a lawyer to kind of take the case because they know they can get paid from the other company. So that's one. I think generally, though, to start from, you start with warnings, right? You start with, hey, like I said, they may not have read your contract. They may have just signed it. So, hey, you're doing something that's out of compliance, right? You stop it, stop it, and then, see what they do. A lot of times in a contract, you may have a certain amount of time for them to cure the problem that they had, right? So for example, let's say they were supposed to pay you on the 2nd, right? If your contract has a cure provision, then they may be able to, you can send them a warning and then they can fix that in time, right? And so it just kind of depends. I think what's important is you want to at least have an initial conversation about when they do something wrong. Either call them up, send them an email, and say, hey, this is the issue, and see what their response is to that. That's where I would always start, is just having a conversation, either written. I like to do it written because I'm an attorney, so you have proof that you told them there was an issue, but also calling them up and talking to them about it and seeing what the solution is. Sometimes it's done accidental, sometimes it's done on purpose, and I think at some point, these problems may lead to you having to go hire an attorney. That's why the attorney fee clause is also important.
Obi, should somebody ever be skeptical about being the first party to sign a contract, or is that not really anything to be concerned about?
Not really. I'll be honest, not really. I think, the contract, you should always get your contract back signed. Though, what I see a lot is that you sign it and you never ask for the other signed part back, right? So you should always make sure you get it signed. I prefer, obviously, to sign at the same time, but that's not always the case. I mean, especially now, it's just not always the case. But I wouldn't really be super concerned with signing it. But when I sign something, I would keep that one copy of myself so you can know that the one that they signed isn't changed, right? But I wouldn't, it's not a big deal to sign who signs first.
One additional question, and I feel like I'm hogging the conversation. So if others have questions, please raise your hands or unmute yourself. Some artists, we talked about artists are small businesses, and some folks actually have EIN numbers and LLCs, and they actually have a legal business entity under which they do their arts practice. When entering into a contract, do you recommend entering into it as an individual, or do you enter into it as your legal business, whether that be an LLC or something else?
Yeah, I think I have an answer that most attorneys wouldn't give. My answer is you want to enter in it as a business, but I will tell you, you don't need to run out and start a business. That's not always necessary that you need to do. Start doing the work and then go get some money and then go get a business and start it. But ideally, you want to sign those contracts as a business if you can. But if you don't have an LLC set up already, that shouldn't stop you from going out and trying to do something. You can sign it as an individual as well. That's not a problem. What it does do, though, let me give you the reasons why you do want to sign as a business, or particularly an LLC. It prevents you from liability, right? It makes the liability limited to your company instead of you personally. So it's always important, meaning like, if you had a sculpture and it fell on somebody, right? Who gets sued, right? If you have an LLC or a company, they can only sue the company. They can't go after your home or your business. Sorry, not your home or your car. They can only go after your company, right? If you sign it as an individual, they could definitely go after everything that's in your personal name as well. So ideally, you want to sign as a company. That's first and foremost, but you shouldn't let that prevent you from starting.
Do we have any other questions from the group?
I have a question. It's Aaron. Can you guys hear me?
Yeah, go ahead, Aaron.
I have a question about, and hi, Obi. The kind of royalty situation when it comes to artists. I know it's a huge issue, but a lot of us are just like emerging artists. We're at the bottom end of this thing and kind of, trying to find our way up from there. So when I do sell something to someone, should I put something in my contract that says like, or can I put something in my contract? Like if you take this work and you sell it to the next buyer, is anything due back to me? Like, do I have the option, in like today's art world to even put that in the contract at all?
So I know that's a big topic in the art world right now. Like I know that's a huge topic in the visual art world. And there's kind of, to be honest, there's no like decision. There's no kind of like yes or no on that, whether how enforceable it is yet. I would say if that's something that you really want to do, put it in your contract. It's a lot easier to enforce it if they've agreed to it ahead of time, right? I think I would try it. I mean, I'll tell you, and I've been reading on this particularly. It's an interesting kind of situation. You make this piece of artwork, you sell it to somebody, then they go and sell it for $1 million. The artist gets nothing after that, right?
Right. Yeah.
Artists deserve anything, and there's two kind of different schools of thoughts. Once you sell it, everything else. Once you sell a car, if you want to go back, if they sell the car after that, you're not going to get the money for it. But art's different, and I think you can go in and say, hey, you've agreed to this, and I think it will hold up in most places. You've agreed to that ahead of time. That's what you put in your contract. If I was writing a clause like this, I would make, I would have, sometimes you have the clauses where you have them sign again or initial apart. I would make them initial that extra just so they make sure it's clear that they understand any resale of this is going to allow you to, for that. The problem is enforcement, right? How do you know when it was sold, right? How do you know what they sold it for, right? I mean, those are other issues, but as far as if you can find that stuff out, yeah, I would have it in your contract.
Okay. And then I have one other question. I think what I'm finding now as I sell more and then I'm having more exhibition opportunities, that sometimes I need the work back from people, for a period of time. So I putting that into the contract also, like some sort of like loan agreement or something like that. I mean, of course, they would always have right to refusal, but I am getting in situations now where I may need to pull something back from someone's house for a particular show. They would still own it and it would be listed that way, but I'm thinking like I probably need to start adding that into the paperwork as well.
No, I think that's great. I think, I think one of the things you can also do instead of a sale is what we call as a long-term lease, right? And you can write it as a lease where it's for 50, 60 years, right? And so like when you lease a car, you have certain kind of can't take it over this many miles, right? You can't do this, this, and this. A lease kind of gives you also a little bit more of a stronger contract law as opposed to a sale. And that may be something to think about as well, is maybe you're giving people long-term leases instead of selling it to them directly. That allows you to pull back for shows and things like that as well.
Do artists actually do that? I've never heard of it.
I mean, it's what I'm seeing it. What Aaron's talking about is kind of new, and I'm seeing people kind of redesigning how they do these contracts, right? And I think I've seen these leases for other types of things. I don't see why it wouldn't work for maybe artwork. I think what the question is whether or not the owner wants to do that, right? I mean, your contract, two people have to agree, right? And if the owner is not willing to do that, then you can't do that. But I think calling it a lease instead of a sale, or the gallery agreement is different in a lot of ways. It's a similar type of lease, right? They're holding it, they're responsible for it, and then they get it back. Maybe you're doing that instead. So
I think that with NFTs, you're starting to see these ideas of sales and artist rights. I think coming back up into conversation in ways that they probably haven't in the art world for the last several decades, especially that topic that Aaron talked about first, about like the resale value. I know with a lot of NFTs, the way they're coded is that every time a future sale occurs, an automatic portion of that sale is pushed back to the artist that originally created the work. So I think what we're seeing occur in a digital space around digital artwork is actually starting to really influence a lot of conversations around what artists of tangible work should also be thinking about as far as their rights. And
really the NFT conversation is interesting because a lot of times you aren't getting the artwork in your house like you would with a physical piece, right? And so there's a little bit of that already, where it's not the same kind of ownership as what we've always done.
Yeah, I think that with the NFTs, it almost is like it's a long-term lease, right? Like you don't actually own the physical aspect of it. You own the digital rendering of it, which you could show on your wall by having it on a screen or projecting it, but you don't ever actually own that physical piece. So when you're talking about that long-term lease, it's I don't know, there's a lot. I'm going to imagine that the business side of the arts is going to get really interesting and possibly slightly blurry over the next 2 to 5 years as things like NFT become I think more and more accepted.
Yeah, and I think the one thing is, I will say, and this is what I said in the beginning, is that's why you want your own contract. Like, that's why it's important for you to try to start with your own contract if possible, because then you can add these clauses, and you know what? Let the judge decide if they want to hold it up. You've put that out there, you've decided, you at least have that opportunity. And a lot of times you may not get everything you want in court, but you may get portions of it. They may say, well, we like this, so we'll give you a portion of it. But if you don't start with your own contract, then you'll never have it work. And the other thing about contracts, sometimes they're enforced just because they read it and they won't challenge it, right? A lot of times if you show someone something in the contract, they're not going to challenge it. They're going to say, oh, I signed it, and they're going to move on. And so those are things that that's why you want to have it in there, because not every dispute goes to court. Sometimes you say, hey, clause A 2.4 says this, and they go, well, that's it. Now, if you have an attorney, they'll probably, they'll tell you to challenge it, but otherwise, sometimes that's why you do the contract. It gives you a level of enforcement that you don't always necessarily have to do something.
Do we have any other questions for Obi while we have him? Obi, if you're getting ready to work with someone that's a legal professional, an attorney, what are some questions you should ask your attorney to make sure they're the right attorney for you?
Yeah, that's honestly, Patrick, you get the award today for questions. These are great questions. I think first is, have you done a contract before for an artist, right? You should ask them about things that you need in your contract, and you should see how they're responding to them, right? So if you're a visual artist, right? Or let's take a photographer, like I said before, right? You should ask them, say, hey, I want to make sure that I keep access to my B-roll, right? I will sell them the final portion and that's it. And I want to keep access to my B-roll. His response to that will let you know his or her response to that will let you know very quickly if that's an attorney that you need to be dealing with. So bring up your issues, ask them questions about it. Ask them, hey, do you have a sample contract that I can maybe look at a couple clauses? I would also ask for recommendations. Ask for people that other artists are working with in the area. Like some people are just off, out of law school and they want to do this work and they've never done it, right? You want to make sure that you're working with people that have done this before. And you want to ask for recommendations of their clients, right? Do you have any clients that you've worked with that I can talk to about this, right? If they don't have anybody that they're willing to tell you to work, that they can work with, then that's a red flag as well. But then you also want to ask them, how am I paying you? Is it hourly or flat fee, right? You want to know what that is. You want to know if it's an hourly rate, what's the rate? If it's flat fee, how much? When is the money due? Is it due all up front, which is common? Those are questions you want to get out in the open as well. What happens if I do get sued? What is your rate for that, right? Because some people, they'll do the contract for very cheap, but if you get sued, then you can't afford them, and you don't want that type of lawyer as well.
Obi, when you send that slide over of the 8 things to consider in a contract, maybe if you could also, if it's not too much work, type out those questions that you just talked about that you should ask your attorney, because we can include that in our recap post, and I suspect folks will appreciate that.
Definitely.
I have a question. Sorry to interrupt. I was just wondering, are you aware, are there attorneys who just specialize in working with artists?
There are. There's different. So in the art world, there's kind of music attorneys, right? That are specifically with music. There's some fine art attorneys as well. I think there's few, like what I do is a lot of small businesses, and then kind of how my practice kind of grew is I just met a lot of artists that needed help with their contracts. And so I work with people from fine artists to basically photographers and videographers. So there are attorneys. Most of the time they're called IP attorneys. That's probably the term that you should look for. And those will be the ones that will have kind of the information that you need about that. But you can look up artists. Then like if you get something from a gallery, ask them who their attorney is, right? Who's their attorney? A lot of people, it's not a huge field where people are only doing that unless you're doing kind of music or video or TV, but there are attorneys that just do this work.
Obi, I'm going to build upon that question. So talking about this idea of coming to terms and agreements with your own lawyer, and as Aaron mentioned, as you're growing in your career, you might not have access to disposable income that might be necessary to fund some of these legal fees. What is your thought on bartering with your attorney? So if you are an artist and you are creating something that has value, what are your thoughts on entering into an agreement with an attorney saying, in exchange for your services, you are receiving this thing from me, whether it's a sculpture, a painting, etc.?
So the background behind me, my logo up there, all were done by a graphic designer that we barter with. I kind of review her contracts. She provides me with graphic designs, all of that kind of stuff. And so, yeah, I'm all in favor of that. If you can do that, I think you just got to be careful because sometimes the trade isn't fair, right? I think you just got to be careful about that. But I'm all in favor of that if they're willing to take, if they're willing to take a piece of art to review a contract, or they're willing to do that. Sure, I don't have an issue with that at all. I just, but I'll tell you, the artists usually are the ones that are getting ripped off sometimes in this. And so you just want to be careful. And you also need to know the value of your work, right? You need to know the value of your work and the value of what you're getting. You know, if I'm getting a huge painting and the contract's $1,000, you probably will sell that painting for $5,000, right? And so is it worth your art for that? You know, that's something you got to know what the value is. So.
Any other questions?
So do you need a lawyer for a contract, or can you make a contract, sign it, and it be valid if the other person signs it?
You do not need attorney to write up a contract. You do not need one. I advise, though, that you do get one, or at least have someone kind of guide you. There's several good contracts online, and they're also very good starting points for you as well. But there's no legal requirement that your attorney needs to write a contract for you. Now, you can't write a contract for someone else because that would be you acting as an attorney. But for your own self, you can go and write a contract and give it to someone.
Obi, I had a question. And if you can't answer this, that's fine. But when you work like with your clients, do you charge them hourly? Okay, and then they can just approach you as they get contracts, or do you have like a contract with the artist that's like, hey, I'll review 6 contracts for you per year? Does that question make sense?
No, I can answer that. I don't have like a plan or whatever, but I do work with artists on a flat fee just so they know what they're getting into. But every kind of situation is a little bit different. So what I do is I sit down with them. I say, hey, what do you need? And I figure out what it will cost, right? I don't have like 6 contracts for this because all contracts aren't the same, right? Some contracts are 40, 50 pages. That's not going to be the same as me reviewing, a one pager, right? And so what I do is we sit down and we have a meeting or consult or what we call it, and we say, hey, this is what this is going to cost. So it just depends. And I think you should be wary of one size fit all legal representation because every situation is different. And the whole point of you having an attorney is for them to help you with that particular situation. And you don't want someone to give you something that is going to not work for your particular situation.
I've got another question. So one of the things that we talked about was deadlines to include within a contract. And so I'm thinking about anytime we build a budget for a project, we always add in a little bit of a contingency just in case we're over what that budget is. We're not scrambling. When you're estimating a timeline for a project, and I apologize for everybody on here that's not a visual artist. I feel like a lot of my questions I've been using visual art specifically as kind of the case. But let's say you're working on a mural and you say this project's going to be done in 4 weeks, and you truly think it's going to take you 4 weeks. In your contract, should you say 5 weeks, 6 weeks, etc., just to give yourself that buffer? Like, how do you recommend approaching a timeline so that your back's not up against the wall and you find yourself out of compliance?
So this is where the particular situation really, really matters, right? So we'll just take the mural for example, right? You say 4 weeks, right? What happens with a mural, and this is what I tell my mural clients, is like, hey, what about rain, right? What about weather issues, right? And so what you want to do is now put in clauses for that, right? Hey, this project is going to take approximately 6 to 8 weeks, depending on weather. Weather days, if there's a day that we can't work because of weather, we'll send you a note. That day does not count against our days, right? I would always give myself some extra time regardless, right? But then the client has issues too, right? Sometimes these murals are for the opening of something, right? And so sometimes they're like, we need to meet this deadline, right? So you should, but also though it's important, the most important thing about business is knowing your work, right? Really knowing how long it's going to take you. Because if you have a client that wants a mural for the opening of an event and you tell them it's 5 weeks, but really the project takes 8 weeks, and now they missed the opening, there could be some clawback for that. But I would, to answer your original question, yes, give yourself some extra time, but also think wisely about the project itself and say, hey, these are the things that could stop me from doing it, right? I remember there was like a paint shortage or stuff like that happened. Those are, we call those kind of like act of gods or things like that. You want to have clauses in there for those things, but you really need to know your work, right? You really need to know what it takes for you to do the job that you want to do. And can you provide that, right? You shouldn't enter into a contract if you know you can't provide what you're planning on providing.
I'll ask one more question, then I promise I'll shut up. So a lot of what we're talking about,
Patrick, and the thing about questions is other people have the same questions. You've asked really good ones, and that's sometimes people have the same questions, they don't want to ask them. And so please ask these are great questions, and that they've actually, I'm going to include some of these into my next presentation. So thank you.
we can tag team that, Obi. You and I can hit the road together.
Yeah.
You start your presentation by saying you're an artist, you deserve to get paid. And I 100% agree with that. There are some circumstances, however, where you might decide to do something without compensation, perhaps because your compensation is non-monetary, such as an opportunity to learn, gain experience, etc. So there's a wide array of reasons why you might enter into a project where no financial transaction occurs.
Mm-hmm.
Is it still important to enter into a contract even if no money is exchanging hands? And how do you perhaps acknowledge within that contract that no money is exchanging hands?
Well, you're always going to have a compensation part of your contract. If you do a contract well, there will be a clause about compensation and how you get paid. I think no matter what, while you're doing it, you should have a contract, right? I think it's extremely important for a lot of reasons. Like, you may not be getting money, but your name is on there, right? You want to be able to say, hey, I did what I was told to do, right? You want to also protect yourself from liability, right? You also want to protect your intellectual property, even it's still your work, right? So there's all those issues that are up there. Pricing and compensation were just 2 of the 8, right? There's still 6 other issues that have nothing to do with like direct money, right? And that you should still have in there. Maybe you want to quit that job, right? It's not worth the whatever compensation they were giving you, and you now need to end that, right? And your contract will talk about how that will work, right? I think no matter what, and I think, no matter what, you should have some type of agreement about the project written out. That helps with a lot of disagreements. And so whether or not you're getting paid or not, it's worth the trouble to have that.
Antonio, I know you joined us a little late this evening, and I'm not sure how much of Obi's presentation you caught, perhaps even on Facebook Live, but I know you've been entering into a number of different projects recently. Do you have any questions by chance that you'd like to have answered? And just so you know, there you go. Antonio, it's hard to hear you. I'm not sure what's going on with your mic, but it's hard to hear you. But if you do have a question and we can't get the mic resolved, feel free to type it into the chat function and we can ask it for you. But it's a bit hard to hear you.
Can you hear me now at all?
Yeah.
Okay, so how do you break down your milestones in your contract? Is it always half upon signing and then half upon completion? Or do you have other milestones in there where you get compensated a percentage?
That's a great question, and I meant to say this. Patrick asked a question, and I meant to include this. So first thing is, I tell artists, do not do half and half, because if the first half doesn't pay for your hard costs, what is the point, right? If the first half doesn't pay for your hard costs, like, I don't know what kind of artist you are, Antonio, but let's say you do murals and you have to buy paint, right? Your paint costs you $1,000, right? The whole job may be, $1,500. If your deposit doesn't pay for your hard costs, you're going to be stuck. The other thing is, I work with a lot of graphic artists, and I don't think you should do half and half. You should do milestones along the way. I like more of the contractor model, right? I don't know if anybody's hired a contractor to work in their house, right? But they have draws, right? So like they finish 25% of the work, they get a draw. You show me the final, like what you plan on doing, the final presentation, you get another draw, right? Then you're getting payments along the way, and then you leave a little bit towards the end, right? That way, if they want to change and do all this stuff, they're already in. They're already in 50%, 60% because you've spaced it out. I don't like the 50-50 thing unless it's like a small project, unless you get a big enough deposit. I hate the 50-50 thing. I prefer at least four small payments where, hey, you get a deposit to hold my time. You get another 25% after I presented you what the final project will look like. Then I get another 25% if I've done 30-40% of the work, right? Completion, and then the rest at the end, right? Because that half and half will always leave you stuck. And what you have is what you have sometimes. And so be careful about that. But I always tell people, at least make your deposit your hard costs. I have some videographers, right? Or a photographer. You're hiring let's say you're hiring a second photographer to work on the project. You got to pay that guy. So your deposit should at least include paying him. And sometimes you tell them, listen, your deposit is to pay for this second person and whatever. But that's where you can cover your hard costs. Good question.
All right, thank you. I got another question, right? So how do you handle, like, if, barring natural causes, say there's just an irreconcilable dispute between you and the person who wants the mural, right? What in your contract, do you have a clause in your contract that says it goes to arbitration or some nut shit like that? Or how do you deal with that?
So that's difficult. You obviously want to have a termination clause in your contract about how, if you guys can't agree, how this is going to end, right? Sometimes you have an arbitration. It depends on you. Arbitrations cost money. Arbitrations cost $20,000 or easily for an arbitration. Sometimes you want to go to a mediation instead. And mediation is a lot cheaper form of kind of figuring it out than an arbitration, right? And so you need to know what you're able to do, right? How much is this job worth, right? Like that's why I say every contract situation is different. Is this a $1,500 mural or $50,000 mural? That's going to make a big decision on how you want to end this, right? Or how much you should get paid. I personally think if you're giving them a contract to do a mural, you should make it towards you, right? But that's why you have kind of you start even further back where you say, hey, I need approval of what I'm going to do to go forward. And that approval, they pay you 25%. So now you have in your contract, you say, hey, they've approved it. They signed my approval. It's going to make your case a lot stronger if down the line they want it to be changed. So to answer your question, there's arbitration clauses, there's mediation clauses, there's all kinds of different clauses that you want to have in there. But I would say first you need to think about what is the cost of this project? Like, is it worth my time to want to do a $20,000 arbitration for this? Or is it something that I just want to be able to walk away from, right? And sometimes you put that in your clause. If they say, hey, we don't want you to do this anymore, everybody walks away, you pay what you get paid and you move away. I think you got to look at everything, especially on these projects, at one at a time. What is this project about? How much am I going to get paid for this project? Is it worth my trouble if they don't like it? Does that answer your question, Antonio?
Yeah, absolutely. Because well, I'm always including this arbitration clause because I've seen it before in others, but I'm like, there has to be an alternative because that shit ain't for me. So you just gave me the mediation clause, so that's gonna go in my contract from now, my man.
But sometimes, Antonio, you just want to walk away, man. Like it may not be worth having to see these people again. Like I'm serious. Like it may not be worth it. Like, arbitration is expensive. Mediation is a little bit cheaper, but it can be expensive as well. But sometimes you just want to say, hey, if you don't agree, and if you do your payment system right, it's much easier for you to walk away. You never want to, and that's why I'm a big proponent of kind of quarterly or more payments than the half and half, because then you're holding the bag as opposed to them holding the bag, and then you feel more comfortable walking away. You have, if they paid you 75% of the thing and they're still arguing with you, and your contract has a termination that we walk away with, why wouldn't you just walk away? You know what I mean? You don't need to see them and go to mediation for the last 25% of it. So put the focus back on you getting your money, as much money as you can up front, or at least in sections, and that way you're getting paid along the way.
Obi, sorry, go ahead, Antonio.
No, that's good information.
Obi, this feels like it might not need to be stated, but I feel like oftentimes those things that feel like they don't need to be stated are the things that actually need to be stated. But should your contract ever include or always include anything specific to not granting permission to others to modify your work? So I can think of a few different occurrences where somebody might seek to modify your work. In particular, again, just building off this example of a mural, say you get into a dispute about the completion of the project, or maybe because of rain, you're delayed, but you have in your contract that those days don't count against you, and the client is looking to have everything done before a specific date, so they bring somebody else in to finish your work. Or maybe you're starting a graphic design project and you give them the working files for one reason or another, and they have somebody else finish that work out. Should your contract specifically state that nobody is granted the permission to modify or complete your work on your behalf?
Yeah, that's the IP part of the contract thing that I said. And one of the things I would also look up, and I'm trying to find it now, it's called Creative Commons, right? It's called a Creative Commons license, and it has some examples. I'll post the link here in the thing, and it has different examples of different types of licenses you can give on your work. So one is, hey, you can use, and the one that, the mural is a little bit different, right? But one of the ones I usually see this a lot for is for videographers, right? They sent this final piece of work, right? And then they're asked, can I modify it? Can we add to it, right? And what Creative Commons does is it gives you different levels of kind of licenses to your work, right? So it's like you can modify it, or you can sell it, or you can not modify it, but you're allowed to sell the final copy without modifying it, right? Like there's different levels to what you can do to your work. I think it's always important in your IP portion of your contract to discuss that. If you don't want somebody coming in, some people don't care. Some people don't care. Some people, it's a negotiable term. Like, hey, if you want somebody else to finish it, you have to pay me $10,000, and they're fine with that. I think it's something you negotiate with. But some people care about their work, and they don't want anybody else to finish it, right? And so if the contract's terminated, then you're saying, then I'm going to go back out, and I have 30 days to basically black it out. If we're talking about a mural, right? Or, this is how it's going to end. I think it's super important, though, to have that discussion, right? About what is going to happen with the work after it's given to you, or what you're allowed to do. Some people, you pay me enough, I don't care what you do to it. Some people are always going to care, no matter the cost. And so it's important for you to have that discussion if you care.
Danielle, you're muted if you're asking a question.
Yeah. You keep on talking about the IP part of the contract. I don't know what the IP part is. What is the IP? What does that?
That's what it stands. It stands for intellectual property.
Yeah.
Basically, that's the ownership of the thing that you created. And so how do you decide where you go with the ownership of what you created?
Danielle, if you go back in our archive of videos, maybe 2 years ago, we have a webinar that's completely about intellectual property right within the creative sector. That was led by an attorney in the Erie area, Jonathan De Silva. And I'd recommend taking a look at that if you haven't already. There's a lot of really helpful information there.
Okay, wonderful. Thank you.
Mhm. Danielle, as you think about working with your gallery, I think one of the things that you might want to take into consideration within this contract, if you haven't, is how long until your work is returned to you. I'm not sure if that's something that they would naturally address within the contract, but if, one, obviously, what's their commission? And then with that commission, what are they doing on your behalf? Are you getting just the exhibition space? Are they going to be developing a marketing catalog with your work, reaching out to clients? What's that commission that they're going to take off of that? But for the work that doesn't sell, once the show concludes, how much time do they have before they have to return the work to you?
Right. So I have a couple of things going on. The galleries, usually there's a certain amount of time is pretty clear and they work on a commission. But this is somebody who is getting in touch with me for I think it's an interior designer, wants it for a project. So which would also be different than if it was a person who owns the house, so a private person. So there's all these different possibilities. So I have sold to individual people and it's theirs and they do what they want. I don't really have a contract. The contract is, it's like a vase, it's yours. That's what I've done up now. It's just a wall, they're pieces. Yeah, so this is all a lot to think about.
The other thing too with that is if it's an interior design opportunity and whether it's a direct commission or a lease or something along those lines, thinking about how you want to be credited within that, right? Because inevitably they're probably going to be taking pictures of that and it's going to be within their portfolio on their website, maybe their print collateral. How do you want to be credited in all of that marketing collateral? Do you?
I think that's extremely great. Like, I think that's a very wise thing, Patrick. Like, you could put in your contract, they could, like, similar to a gallery where they have to name you and what the work is, what the cost of the work is. You could say, hey, this needs to be posted by my artwork, right? You could do that if you want, right? I think that's extreme. And then when they're going to take photographer pictures, right, you want to be credited. And that's one of the creative licenses is, you have to credit me whenever you're posting this work, right? And so you definitely want to be able to think about that because that's also how you make money, right? That's also they're seeing your work. Now they go and look you up and then they want to get something from you, right? And that's not always something, that's a negotiable term, what I call a negotiable term, right? So maybe you say, hey, for this amount, you do this. And if they're super opposed to it, then you raise the price, right? You say, well, if you don't want that, then fine, I'll pay, you have to pay this. If you do want to credit me, then you need to pay this. It's a lower price, right? Those are all negotiable terms.
Yeah.
I'd also say in that same situation with those photos, if they're taking, professional photos to document their work, including within that contract, that you also have the right to use those works for your own marketing purposes. So long as, again, you're also crediting them in that process. But, if you're doing something with interior designer, chances are they're going to have a photographer, they're going to document that work, and being able to represent that within your portfolio and marketing collateral, having the right to do so is equally important.
Yeah.
Yeah.
I almost rather have that to work with, this is almost like a third party, like an intermediate, because when you sell a work directly, then it's that's gone. It's
Right.
becomes, nobody can see it. And one of my favorite works has been, fortunately, it was documented and it's out there from the staging people. But yeah, it's I'll never, it's like in a vault practically, and that's a bummer because, when it's in a gallery, at least it gets to be, get some exposure.
And I think that with what you're doing in particular with working with stagers and interior designers is it's really important to recognize that they're using your work for a commercial purpose and commercial gain, which is very much different than purchasing it for a private collection, which is why I think that the terms and conditions of that usage, that sale, that lease, like you can be a little bit more stern in it because they're making money off of you, right? Like you are contributing to their aesthetic and their success.
Which is where I feel like had I done this workshop, attended this, I would have known that I really didn't need to give them the commission that I would have given to a gallery, because they did use it in their promoting things. And in a way, they could have had a smaller commission than a gallery because they were getting this for their own promotions too. So I did not calculate that in the DLN.
Well, two things too that Patrick said that kind of brought some things to mind. A is, from a legal standpoint, your contract with another commercial entity, you have more leeway. You have in the courts, they're going to look at that commercial entity as another business, and they're going to be less likely to strike down something that you gave them. So that's one. But the other thing, Danielle, I saw how your emotion was when the artwork was going to be put in a vault or put away, right? And I think that's the kind of things, though, I tell artists to think about when you're pricing your work, right? Because you need to ask these questions, right? You have as an artist, you have an emotional connection to this work, and so you have to price that out, right? Sometimes there is no price, but sometimes there is, and I think it's important for you to kind of say, hey, what are you going to do with this work? And that's part of your contract and your pricing, though. But you should think about the whole course of this, right? Is this going to be shown to people? Is this going to be put away, right? And if that's the case, right, then I need to charge this, or I need pictures, or I need, I need to be able to take it out for shows, right? Those are things that you need to be thinking about when you talk about your art.
To what Erin was saying. So if you do want to, if you sell it to a private person, like it's in their house now, but I wanted to use it maybe in a show, if I was ever to have a show, do I have any, I'd have to just ask them at this point but it's a big piece in their center of their house. So I don't know if I could, but next time, how would I go about?
I think you want to always, in contract negotiations, I think it's always good, especially to have the conversation, right? Before you start putting stuff to paper, you want to have a conversation. You want to ask them, hey, if I sell you this piece, can I come back and use it for shows, right? Or how many shows a year? They may ask you how many times a year would you want it, right? You can negotiate, hey, you get 3 shows a year. You get 2 months out of the year, right? And that difference the price, right, of what you're selling it for, right? So you want to have these conversations with people, but that's why I say at the beginning, know your work, right? Know what you want to do with it, know how long it takes to make it. You need to know what you want to do with it after the fact, because if you don't, you can't ask those questions at the beginning. And that's what's important.
Thanks.
So we're about 10 minutes after 7, so we should probably start winding down, but do we have any additional questions for Obi while we have him? And Obi, maybe you could type in your website and email address in the chat function, should anybody have questions after this?
And I thank you guys for having me. I love doing this because I think you want to empower people to be able to really do what they really want for a living. And you can't do that if you're not making money doing it. You got to eat, you got to pay bills, and so a contract enables you to do that.
Well, Obi, I want to thank you so much for being present with us and giving us your time this evening and sharing your knowledge with us. It's an incredibly important topic, and as often it can feel as artists, I think we all want to think of ourselves as approachable and personable and kind of the humanistic side of the world. And sometimes these ideas of contracts can feel like it strips away at that a little bit and makes us move into that realm of like corporate business. But I think that contracts really are what helps mitigate and then navigate conflict as it arises. So I think it's something that every artist should really be taking seriously as they embark on projects, collaborations, commissions, all of these things, so that you make sure that you are protected. So I just want to thank you, Obi, for not only the time you shared with us this evening, but all the work you do with artists throughout Northeast Florida. I know quite a few who have worked with you, and I know that you advocate on their behalf. So thank you for that. Again, the Pro Network series through Erie Arts and Culture is funded in part by the National Endowment for the Arts through their Artworks grant. Our next discussion is later this month with Beehive Dramaturgy. It's about how to give and receive feedback to artists and their collaborators. I believe that is October 27th, and there is a link in the chat function to that. Also, Danielle, Jay did include the link to the intellectual property webinar if you want to go back and watch that. But I thank you all and look forward to sharing space with you here in the near future. Have a good evening.
Thank you. Thank you, Obi. Thank you, Patrick.